tweeted, quote, pass universal background checks and ban assault weapons and high-capacity magazines.
With solemn honor for our children who will grow up in a better and safer world.
Take meaningful steps towards curbing the unacceptable gun violence on our streets.
On the comprehensive steps we can take to ensure every community can live healthy, safe, and well.
Background. The recent denial of emergency relief by the Supreme Court in 2 cases challenging Illinois' rifle and mag ban has significant implications for arm owners in the state. This decision, amidst an impending registration deadline, adds complexity to an ongoing legal battle. While the denial is a setback for those opposing the ban, there's a glimmer of hope amid the legal intricacies. The case in question is the Calkins v. Pritzker lawsuit challenging the constitutionality of the Protect Illinois Communities Act, or PICA. PICA imposed restrictions on rifles and mags, requiring a registration process for certain firearms to be grandfathered in. Notably, this case involves different procedural backgrounds influencing the recent developments. The legal journey began when a state lower court in Illinois, after reviewing the case, declared the ban unconstitutional, citing a violation of equal protection under the law. The lower court determined that the right to bear arms, both under state and federal constitutions, constituted fundamental rights, subjecting the legislation to strict scrutiny, which it failed to satisfy. Consequently, the court ruled PICA void and unconstitutional. However, the state of Illinois appealed this decision to the Illinois State Supreme Court. In a significant turn, the state Supreme Court reversed the lower court's decision, reinstating the validity of PICA. The reversal raised concerns as it was revealed that 2 of the state Supreme Court judges may have received substantial contributions from defendants involved in the case, leading to allegations of bias. These concerns about potential conflicts of interest and the influence of financial contributions have added layers of complexity to the legal proceedings.
By law-abiding citizens for lawful purposes, and therefore cannot be banned.
With solemn honor for our children who will grow up in a better and safer world.
Said we want to protect our communities.
Despite the state Supreme Court's ruling, the legal battle continued and emergency requests for relief were filed with the U.S. Supreme Court. Unfortunately for arm owners in Illinois, the Supreme Court denied these requests, leaving the rifle and mag ban in effect. The denial of emergency relief by the Supreme Court underscores the challenges faced by those seeking to challenge state-level gun regulations at the federal level. It also highlights the legal intricacies surrounding emergency injunctions and the Supreme Court's discretion in granting such relief. While this denial is undoubtedly a setback, it doesn't necessarily mark the end of the legal road for these cases. The denial doesn't address the merits of the unconstitutional claims raised by the plaintiffs, leaving open the possibility for further litigation on the substantive issues. In supposition, the Supreme Court's denial of emergency relief in the cases challenging Illinois' rifle and mag ban presents a hurdle for arm owners seeking immediate reprieve. However, the legal battle is far from over, and the complex procedural history, including concerns of bias in the state Supreme Court, adds layers of intrigue to the ongoing litigation. The ultimate fate of PICA and its implications for gun rights in Illinois will likely depend on future legal developments and potential hearings on the constitutional merits of the cases. Legal maneuvers. The ongoing legal saga surrounding the challenge to Illinois' rifle and mag ban involves a complex series of legal maneuvers and decisions. To grasp the current status, it's essential to dissect recent developments and understand the strategic choices made by both parties. Following the Illinois State Supreme Court's decision to reverse the lower court's ruling and uphold the constitutionality of the Protect Illinois Communities Act, the plaintiffs in the case known as Calkins v. Pritzker took their challenge to the U.S. Supreme Court. This legal move involved filing a right of certiorari to the highest court seeking a review of the case. A critical aspect of the current situation is the state of Illinois' decision to file a notice of waiver with the U.S. Supreme Court. This waiver indicates that the state will not submit the required response brief, a document traditionally expected by December 14th. The Supreme Court accepted this waiver, a move that implies an acknowledgement of the state's decision not to file a response.
Prosecutors filed more than 500 cases involving machine gun style weapons during that time.
Bill was written with constitutionality in mind. It was based on bills in other states where the same ban has been upheld.
It's more to us because we know the impact. We know how it impacts our families and our communities.
Despite this waiver, the U.S. Supreme Court scheduled the Calkins case for review and consideration at a conference on January 5th. This scheduling is noteworthy because it signals that despite recent denials of emergency relief in related cases, the Supreme Court isn't dismissing the Calkins case outright. The conference provides an opportunity for the full case to assess the case and potentially decide on its merit. Simultaneously, while the traditional right was filed, the plaintiffs, including Calkins, also pursued an additional legal avenue by submitting an emergency stay request to Justice Barrett. This emergency stay request sought to halt the enforcement of PICA while the Supreme Court reviews the case. However, Justice Barrett, who is responsible for the 7th Court, denied the emergency stay application on her own without referring it to the full court. This denial by Justice Barrett holds significance because it leaves open the possibility for the plaintiffs to refile the emergency stay request. Under Supreme Court laws, when an emergency application is filed, it initially goes to the justice responsible for that circuit, and in this case, it's Justice Barrett. However, the denial by a single justice without referral to the Supreme Court means that the request could be refiled to a different justice, such as Justice Thomas. The denial by Justice Barrett, while a setback for the plaintiffs, doesn't foreclose their options. The opportunity to refile the emergency stay request with another justice keeps the legal battle alive and underscores the strategic considerations at play. In immediate, the legal proceedings in the Calkins case were marked by a nuanced interplay of traditional legal filings, waivers, and emergency requests. The Supreme Court's decision to review the case at the January 5th conference indicates ongoing consideration, while the denial of the emergency stay by Justice Barrett introduces the potential for renewed filings to a different justice. The intricacies of these legal maneuvers underscore the complexity of challenging state-level firearm regulations at the federal level and the strategic decisions faced by both parties involved. Developments. The recent developments in the legal challenges against Illinois' rifle and mag ban, particularly in the Calkins v. Pritzker case, reveals a nuanced and ongoing legal battle. The denial of emergency relief in the case by the U.S. Supreme Court introduces complexities and leaves the future of these challenges uncertain. While the denial of an emergency stay is not ideal news for those challenging the Illinois ban, the fact that the case is still set for conference suggests that the legal proceedings are very much active. The commentary surrounding these developments may vary, but the reality is that the Calkins case is in motion and there are still opportunities to be explored. The absence of an immediate stay doesn't negate the possibility of future legal actions and the potential for a substantial review during the conference. The National Association for Gun Rights, NAGR, pursued an alternative path by not filing the traditional Supreme Court right initially. Instead, they awaited a decision from the 7th Circuit en banc review, a decision that ultimately ended in denial for multiple Illinois rifle and mag ban cases, including the NAGR case.
Is it the point of the bill to ban weapons that are in common use in the United States today?
Today, we honor them, their trauma, and their loss.
Court, where the last two justices that were elected benefited greatly from political contributions.
The Supreme Court's order on the NAGR case denying the emergency injunction request was straightforward. The application for a right of injunction pending certiorari presented to Justice Barrett and referred to the court was denied. This succinct statement closes the door on the immediate relief sought through an emergency injunction. Comparing these cases, the procedural nuances play a significant role. The Calkins case, with its traditional Supreme Court right filing, keeps the full petition alive for consideration at the upcoming conference. On the other hand, the NAGR case, having already faced denial in the 7th Court, received a clear denial of the emergency relief sought through the Supreme Court. In instant, the recent denials of emergency relief in the Calkins v. Pritzker and NAGR v. Neal cases do not signal the end of the road for these legal challenges. The Supreme Court's decisions, while impactful, leave room for further legal actions and considerations during the upcoming conference. The legal landscape remains dynamic, and the unfolding event will determine the future trajectory of these challenges against Illinois' rifle and mag ban. Supreme Court denials. In the NAGR case, the denial of emergency relief is explicit and final as it went to the full court for consideration. This implies that, at least at this juncture, the emergency injunction request is concluded. Despite the setback, the National Association for Gun Rights has a primary option, filing for Supreme Court review. By submitting a traditional right of certiorari, the plaintiffs can request the Supreme Court to conduct a comprehensive review of the entire case. While such a filing won't yield immediate relief for arm owners in Illinois, it propels the case forward. The absence of dissenting language or statements from justices, especially from staunch conservatives like Justice Thomas in the denials, raises interesting considerations. Historically, Justice Thomas has expressed concerns about the treatment of the Second Amendment as a second-class right. The lack of dissenting options may suggest that the justices are not signaling a complete avoidance of the issue, but rather choosing not to make explicit statements at this stage. This silence could be strategic, hinting at potential considerations for a more thorough review in the future. While the denial of emergency relief is not the ideal outcome, it doesn't entirely foreclose the possibility of future legal actions or a substantive review by the Supreme Court.
Biden, I believe we have too much gun violence in this country.
Take meaningful steps towards curbing the unacceptable gun violence on our streets.
Tweeted, quote, pass universal background checks and ban assault weapons and high-capacity magazines.
The NAGR case may move forward through the traditional Supreme Court review process, allowing for a more thorough examination of the constitutional and legal aspects surrounding Illinois' firearm restrictions. As arm owners in Illinois face the challenges posed by the denial of emergency relief, it's crucial to recognize that the legal landscape remains dynamic. The Supreme Court's decisions are not final destinations on the merits of the underlying cases, but rather responses to the specific emergency relief requests. The possibility of future actions, potential filings to other justices, or even reiterations of emergency relief requests should be monitored closely. The situation is undoubtedly challenging for arm owners in Illinois, especially considering the looming registration deadline. While the Supreme Court denials pose immediate obstacles, the complexity of the legal process and the potential for future developments underscore the need for vigilant observation. The pursuit of Second Amendment rights in Illinois is an evolving narrative, and the next steps taken by the plaintiffs and the legal system will determine the course of this ongoing battle. Update: the U.S. Supreme Court has rejected a request for an immediate injunction to block Illinois' ban on assault weapons and high-capacity mags scheduled to take effect soon. The challenge, originating from Naperville, sought to halt the law while the case was ongoing. Plaintiffs in the case had approached Justice Amy Coney Barrett requesting the emergency injunction, but after receiving briefs from both sides, Barrett referred the case to the full court, which ultimately denied the motion for an injunction. Hannah Hill, representing the National Association for Gun Rights, expressed anticipation for the Supreme Court's potential involvement in evaluating the constitutionality of banning commonly used firearms. In a statement, she shared the court's denial of the emergency appeal and expressed hope that it might be because they're awaiting the official cert petition. The court has already shown serious attention to the case on 2 occasions, and Hill looks forward to providing them with the opportunity to weigh in on the case's merit. Arm control advocates, represented by GPAC, responded to the denial of the emergency injunction by emphasizing that gun rights groups seem to be making little progress. John Smith, a GPAC executive board member, asserted that despite legal challenges, the complete blockage of sales for these deemed destructive weapons in Illinois remains unchanged.
I'm going to read you, so you can still, after this bill passes, you can own an actual weapon of war.
To these high-powered weapons that have an original basis in military and combat have no place in common commerce and on our streets.
Automatic, 3-round burst, or semi-automatic. Those firearms are not allowed for purchase in the United States today.
While the denial of the emergency injunction is a setback for those challenging the ban, it doesn't preclude the possibility of the Supreme Court engaging with the case in the future. The court's previous attention to the matter indicates a recognition of its significance, and the plaintiffs remain hopeful that a more thorough evaluation will take place. As the legal battle unfolds, the key players on both sides continue to emphasize their respective positions. Gun rights advocates view the case as an opportunity for the Supreme Court to assess the constitutionality of the ban, while arm control advocates maintain their stance that the blockage of sales in Illinois remains intact despite legal challenges. The case's progression will likely shape the discourse around gun regulations and constitutional rights in the broader context of U.S. legal and political landscapes. Challenges. As the January 1st arm ban regulation deadline in Illinois approaches, Governor J.B. Pritzker expects the deadline to go into effect. The controversial arm ban, which includes a requirement for arm owners to register their firearms, is facing legal challenges, but Pritzker emphasized the constitutional and safety aspects of the law. The governor asserts that the arm ban is both a legal and constitutional measure aimed at safeguarding the people of Illinois. While the rules for the arm ban registry are still pending finalization by the Joint Committee on Administrative Rules, Pritzker contends that individuals are aware of what needs to be registered. He notes that, as of now, no one is facing charges or arrests related to the registration requirement, and the first violation, if charged, is considered a misdemeanor, escalating to a felony for subsequent violations. Pritzker underscores the primary rationale behind the arm ban registration: the prevention of people purchasing assault weapons in the state. The registry is envisioned as a tool to track the ownership of these weapons, ensuring authorities know who possesses them and providing critical information in the event of crimes involving such firearms. While the governor is confident in the constitutional and legal grounds of the arm ban, legal challenges persist. A ruling on a preliminary injunction against the January 1st deadline is pending in the Southern District of Illinois Federal Court. During recent oral arguments, Judge Stephen McGlynn indicated his inclination not to block the deadline, emphasizing the need for litigants to address the merits of the case promptly. The ongoing legal battles reflect the broader divide and debate surrounding arm control measurements in the United States. Supporters of such laws, including Governor Pritzker, argue that they're essential for public safety and crime prevention. Opponents often challenge these laws on constitutional grounds, particularly concerning Second Amendment rights. As Illinois navigates the implementation of its arm ban and registration requirements, the legal landscape remains dynamic. The resolution of the pending preliminary injunction and potential future legal challenges will shape the fate of the arm ban in the state. The January 1st deadline looms as a pivotal moment, prompting discussions not only about the constitutionality of such measures, but also about their effectiveness in addressing public safety concerns. The Supreme Court's unanimous decision on a permanent arm ban for 2024 has significant implications for arm owners across the affected jurisdiction. The ruling, likely grounded in legal and constitutional considerations, imposes substantial changes in firearm ownership and usage. One immediate implication is the loss of certain arms deemed restricted under the permanent arm ban. Arm owners are now required to comply with the updated regulations, which may involve surrendering or modifying their firearms to align with the new restrictions.
They don't care about that fundamental liberty law-abiding citizens in this country enjoy.
Law does not ask current lawful owners of these assault weapons to give up their lawfully acquired guns.
He should be respected.
Reclaiming my time. So, Mr. Chairman, I'd like 40 seconds.
I've seen my constituents die in battle.
This could involve enhanced background checks, stricter licensing procedures, or additional training requirements for arm owners. Enforcement mechanisms for the permanent arm ban are likely to be robust. Law enforcement agencies may engage in thorough monitoring and inspection to ensure compliance. Non-compliance could result in severe consequences, including fines, penalties, or even criminal charges. The Supreme Court's decision thus places a considerable responsibility on arm owners to strictly adhere to the new regulations. The broader societal impact is another facet to consider. The permanent arm ban aims to enhance public safety and mitigate the risks associated with certain firearms. Arm owners may experience heightened scrutiny as the public and law enforcement agencies assess the implications of the new regulations. This could lead to a reevaluation of the role of firearms in society, with proponents highlighting increased safety and critics expressing concerns about potential infringements on individual rights. Historical context of arm bans. The historical context of arm bans provides a nuanced understanding of the evolution of firearm regulation and its impact on societies. Throughout history, various nations have implemented arm bans for diverse reasons, ranging from public safety concerns to political and social stability. One notable historical context is the United Kingdom's Firearms Act of 1920, which marked a pivotal moment in arm control. This legislation emerged in response to concerns about rising crime rates and political instability in the aftermath of World War I. The act aimed to restrict access to firearms and establish a licensing system, laying the groundwork for a more regulated approach to arm ownership. Subsequent amendments and acts in the UK further shaped the nation's arm control landscape. In Australia, the National Firearms Agreement of 1996 was a watershed moment following the Port Arthur massacre. This tragedy prompted the Australian government to swiftly implement comprehensive arm control measures, including a buyback program to reduce the number of firearms in circulation. In examining the historical context of arm bans, it becomes evident that these measures are often responses to specific societal challenges or political climates. They reflect the delicate balance between individual freedoms and collective security. Historical examples underscore the diverse approaches taken by nations in addressing arm ownership, influenced by cultural, political, and historical factors. Understanding the historical context of arm bans is crucial for informed discussions on contemporary arm control debate. It provides insights into the motivations behind such measures, the effectiveness of different approaches, and the broader implications for individual rights and public safety. As societies continue to grapple with evolving challenges, the historical lens offers valuable perspectives for shaping responsible and effective gun policies. Community advocacy efforts. Community advocacy efforts play a crucial role in shaping discussions and influencing policies related to arm bans. As communities grapple with the impact of firearm regulations, advocacy serves as a mechanism for voicing concerns, mobilizing support, and fostering change. One aspect of community advocacy is the engagement of grassroots organizations that focus on promoting responsible arm ownership and influencing legislative decisions. These organizations often work to educate the public about the implications of arm bans, providing information on how such measures affect individual rights and community safety. By fostering informed discussions, these advocacy groups empower community members to actively participate in the policy-making process. Community advocates also emphasize the importance of dialogue and collaboration. Open and constructive conversations between advocacy groups, policymakers, and community members allow for a more comprehensive understanding of diverse perspectives. These discussions enable stakeholders to identify common ground, explore alternative solutions, and work towards policies that balance individual rights with public safety. Public awareness campaigns are another essential component of community advocacy efforts. These campaigns aim to inform the community about the consequences of proposed arm bans, highlighting potential benefits and drawbacks. Through various channels such as media, community events, and online platforms, advocates seek to reach a wider audience, encouraging individuals to critically assess the implications of gun regulations on their lives. Local community leaders often play a pivotal role in advocacy efforts.
American Progress employee was to reduce gun violence, getting assault weapons, AR-15s.
On the comprehensive steps we can take to ensure every community can live healthy, safe, and well.
And guess what this bill will do? It won't make communities safer. Won't make them safer.
Elected officials, community organizers, and influential figures within neighborhoods have the ability to amplify the concerns and aspirations of their constituents. By championing the interests of the community, these leaders can contribute to a more inclusive and representative decision-making process. Advocacy also extends to legal challenges where community members may join or support lawsuits challenging the constitutionality of arm bans. Legal advocacy allows individuals to address the concerns through the judicial system, arguing that certain measures infringe upon their Second Amendment rights. Successful legal challenges can set precedents and influence the trajectory of arm control policies. Furthermore, community advocacy efforts may involve mobilizing citizens to participate in public hearings, town hall meetings, and other forums where decisions about arm bans are deliberated. By encouraging community members to voice their opinions directly to policymakers, advocates contribute to a democratic process that reflects the diverse perspectives within the community. In conclusion, community advocacy efforts are multifaceted, encompassing grassroots initiatives, public awareness campaigns, legal challenges, and active community engagement. These efforts empower individuals to actively participate in the shaping of policies related to armed bans, fostering a sense of collective responsibility and ensuring that diverse voices are considered in the decision-making process. As communities navigate complex discussions on arms control, advocacy remains a powerful tool for influencing change and promoting solutions that align with the values and priorities of the people. Well guys, that's going to do it for this video. See you next time, and bye for now.